Good afternoon, everybody. How you doing today? Do we need to take a nice collective, calm, and deep breath? What a morning. I was streaming with Eric Hunley on Laid Back Law for Friday morning, and everything lit up with the news that the jury sent in a note indicating that they were deadlocked. So naturally, everyone is in a bit of a flurry, trying to make sense out of what this means. How could this happen? What happens next? What does the judge have the authority to do under these types of circumstances? I have the fan on in the background, so we are prepared to go ahead and bring the court back on as soon as we know that the jury is coming back in, just so that we don't... We can follow what happens as it happens in case there is more information that comes out through the course of the jury being excused. But I know people have about a gazillion questions about what does this mean and what's going on. So here we are live. We're going to talk about it. I have gone in and done the homework because that's just kind of what I do. Gotta look at the law for these things, you know. It's easy to have an opinion about, you know, how stuff should be or what we think is fair and so forth. But the fun thing about the law is that it's actually written down somewhere. It's really a literary process. It's about what you can cite. So I've gone through and tried to sort out through the citations what the legal framework is that we are dealing with right now. So let's start with just a little bit of background. The problem you always have when you have a jury that is indicating that they're deadlocked, but the court is not maybe convinced that that's the case, or is just not satisfied that they have put enough effort into trying to reach unanimity, is the risk that you coerce the jury into reaching a verdict. This would be a basic due process kind of violation, a problem with your right to a jury trial, because the whole point is that people are supposed to vote in accordance with their conscience. They should not be put in a position where, because they are, you know, being held against their will or threatened with violence or something like that, that they would cave on their sincere belief about what the appropriate outcome should be, just so that they can get out of this situation. This has not always been the case. There has been some just fascinating case law, common law. I found this case from New York that's an older case, but talks a little bit about some of this history. It was a case where the New York Supreme Court decided back in 1898 that there had been a coercive handling of the jury in that case that had come back multiple times, reporting that they were deadlocked, and the court's reaction was to continue to hold them overnight, no beds, no food, until you get a verdict. Things used to be done that way, guys. The language in this case that I found quite amusing in a dark humor, haha kind of way. By the ancient common law, jurors were kept together as prisoners of the court until they had agreed upon their verdict. It was regarded not only proper, but requisite that they should be coerced to an agreement upon a verdict. There are some quotes here. One case that they cite says, "The jury, after the proofs are summed up, unless the case be very clear, withdraw from the bar to consider their verdict, and in order to avoid intemperance and causeless delay, are to be kept without meat, drink, fire, or candle, unless by permission of the judge, till they are all unanimously agreed. And it has been held that if the jurors do not agree in their verdict before the judges are about to leave the town, the judges are not bound to wait for them, but may carry them to town in a cart." So that's the old law, guys. As a juror, you're a prisoner of the court. You can be hauled away from your town in a cart until you reach a unanimous verdict. Well, that is no longer the case. That is not the standard that is applied today. Coercive verdicts are recognized to be a violation of just the fundamental principles of due process and the right to a jury trial. Nevertheless, those concerns about coercion, it sounds silly, right? But you start thinking about it. Okay, we're not necessarily talking about like hog tying somebody and throwing them in a cart and carrying them away until they reach a verdict. But they are not at liberty to go back about their lives until this case is over, until the court releases them. So the question really becomes at what point is there a tipping point beyond the point where the jury has acted in good faith and attempted to resolve it, to the point where, and notwithstanding their ability, to not do that, the court has continued to encourage them to try to reach a verdict. At some point, there is a tipping point where, you know what? You've kind of made these people prisoners of the court. You've put pressure on the minority members of the jury to cave, to concede their viewpoint, and essentially abdicate the responsibility they have as jurors that you have already laid out for them in their instructions, in order to simply get done with the situation, get out from under the thumb of the court, and be able to move on with their lives. So in order to accommodate these kinds of circumstances and this balancing between when is the jury allowed to be encouraged to continue, keep working on it, maybe you haven't exhausted every possibility, and that point where, continuing to hold them here is not fruitful, and all it is going to do is just put pressure on people to abandon their beliefs. There's been a lot of case law that has evolved to deal with how to accommodate these competing concerns. Some of this is at the federal level, some of this is at the state level. So in Massachusetts, there's a number of kind of overlapping things that are going on. So first off, they have this statute. It's rather peculiar. I've never seen anything like it. It seems to be unique to Massachusetts as far as I can tell. But it's a specific statute dealing with when the jury is unable to agree. And it says, if a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. So what this statute does, in effect, is it says if the jury has engaged in due and thorough deliberation, can't reach a verdict, you can only send them back out one time. You can't just keep sending them out over and over and over again. That's part of the way that in Massachusetts they've balanced this restriction on not creating a coercive environment. They've tried, they can't get it done. You don't get to just send them out over and over and over and over and over and over and over until they finally figure out what they need to do to get out from under your thumb. So they also then have this instruction, standard instruction that they give under these same circumstances. Generally, same thing, when the jury has engaged in due and thorough deliberations, has been unable to reach a verdict, the court can give this instruction. It's called a Tui-Rodriguez instruction. It's based on the names of the cases that gave rise to the language in this instruction. And again, go ahead and send them back out. So what that instruction says, Our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of the other jurors. Still, in order to bring 6 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. There is no reason to suppose that the case will ever be submitted to 6 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element, beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you now to return to your deliberations with these thoughts in mind. So that is the form instruction that it's likely to be given at some point. So let's talk about what's happened this morning and where we're at. So the key here is that requirement. None of these obligations attach unless the jury has engaged in thorough deliberations. So when they came in this morning and addressed the jury's question, that's the framework in which Judge Bev decided it. She made the determination they have not yet engaged in due and thorough deliberations. And so what that means, this obligation to give this form instruction, it doesn't apply yet. This restriction on being able to send them back an additional time, it doesn't apply yet. Those only apply after there has been due and thorough deliberations. The trial judge has quite a lot of discretion under Massachusetts law to make that determination. They're going to look at things like the length of the trial, the fact that there was an extensive amount of evidence, a large number of witnesses, and relative to the time that the jurors spent hearing the evidence, the deliberations have been relatively short. It may seem long. I can tell you guys the longest deliberation I ever had with a jury was a full week, was 5 days. I don't recall that they came back with a question the entire time. And so it was quite excruciating to wait that through. But the jury, it takes the time. It takes the time that it takes. So in this particular case, clearly they feel like they are at the end of the road, but the judge has discretion to make the determination that just under the circumstances, what you have done so far is not enough. You couldn't have reached the point where it's hopeless for you to make further progress. Just because it's possible that there's more evidence, there's more joint recollection, just different things that if you take the time to go through all of it, maybe that will tilt the scale. So that's why she did not give that Tui Rodriguez instruction already. The defense wanted it and requested it. The Commonwealth did not. And she sided with the Commonwealth on that, determined, nope, they're not at that point yet, so she's not giving it. If they come back a second time, or they come back at the end of the day today and repeat, this is pointless, we're not getting anywhere, there is no benefit to continuing with further deliberations, she'll get the opportunity to make that determination again. I think the challenge is, though, that the further down the road you go, the more time you spend, the more the jury goes back and continues to make efforts and returns to say this is not productive. It starts to become a little bit more difficult to allow the judge to trump the jury's own evaluation of whether they're likely to get anywhere with it or not. There is definitely case law in the federal courts that includes language basically to the effect that you really need to give deference to the jury's evaluation of their ability to make further progress, because that's part of the thing that you have to consider in evaluating, are you coercing them? Are you putting pressure on them to abandon, what they believe about the case in order to satisfy you and get released from further service? So under the federal law, it's pretty clear. These instructions, these decisions about how to proceed in the case of a deadlocked jury, it can be a bit of a minefield. The judge is supposed to be cautious. They are supposed to respect the jury's determination, but it doesn't mean that just because the jury says so, they're absolutely stuck with that. It's just that it's gonna start to look more and more unreasonable for a judge to say, no, you haven't finished yet, when the jury is continuing to tell you, spending hours later and coming back and telling you again, no, we still can't get anywhere. So at this point in time, that's where we're at. We have not yet gotten the Tui Rodriguez instruction. If the jury comes back and indicates we still can't reach a verdict, then the question is going to be, do we go there? Do we go ahead and give them that Tui Rodriguez instruction and require them to take one more chance at it? Maybe think about it over the weekend, come back on Monday and give it a fresh effort to see if you're able to resolve those things. If they made that decision, probably going to be legally okay. I found at least one case out of the Ninth Circuit that actually involved this situation where there's a pause over the weekend, and they said, well, that would, if there had been like a coercive type of attempt before that, the weekend would have sort of diluted the effect of that, and them coming back would just sort of be untainted by any kind of pressure that they might have felt at the beginning of the weekend. So that's frankly what I would expect here. If the jury is still not making progress, if we even know, it's not clear that we're going to hear anything further at this point. The onus is typically on the jury to communicate with the court. It's not that the court can never send back an inquiry being like, are you guys okay? How are things going back there? Are you making progress? But it is just something that they have to engage in with a lot of caution. One thing I've seen a lot of questions about that I want to be very clear is the divide of the jury, the split. We not only don't know, we really cannot know. It's not impossible that the jury would volunteer that, and if they do, okay. But it is flat out prohibited to ask them what the breakdown is. There is crystal clear case law on that. That is per se coercive, because that is putting a spotlight on the minority jurors. Even if we don't know exactly who they are, we know that the minority is being targeted when that's your concern. Well, like, what are your numbers here? The numbers don't matter. The numbers don't matter. The issue is the conscientious belief, and is there a possibility that further deliberations is going to have the potential to change anybody's mind, but not by overcoming them, by simply persuading them to adopt a different perspective. So any reports that you're seeing about the split, disregard them. It's not something that can be known. It's going to be speculation. The judge is not going to be able to ask about it. Typically, the only way you find out about a split, again, unless it has happened, although I think it's pretty rare that the jury will volunteer. If like they're sending a note to the judge, they might say, you know, here's what our vote is, and we're not getting any closer. Rare occasions you might find out that way, but typically it's only if a mistrial is declared, the jury is released, and then they choose to talk about it after the fact, because once they're released, they're not under any prohibition about, you know, talking about their perspectives on the case, who was voting for what the deliberative process was like, and so forth. They just can't be compelled to volunteer that information, and particularly while the deliberations are still ongoing. So that's pretty much where we're at right now. I know everybody is wondering, how can they be deadlocked? How can they be deadlocked? Isn't it simple? Doesn't it come down to, didn't she hit him with a car, or did she not hit him with a car? I just want to remind everybody that we did have the luxury of, while we were watching this over the extended length of time that it took, we were able to put our heads together. We're able to rely on each other and check our own impressions against everybody else in real time. We're able to go back and rewatch the stream of the trial. If there's something that perhaps we forgot or didn't pay real close attention to, we can check ourselves and our recollections of all that. The jury hasn't had that. They don't have those options available to them. And as much as we would love for jurors to be diligently attentive, great note takers, very detailed, certain about what they've heard, and able to verify it and so forth, it's just not likely that that's the case. And so part of the problem is, if somebody comes into the jury room and they have already got an impression of the case, but maybe didn't pay all that close attention to what was unfolding, they could misremember things. Misremembering, that's just sort of the plague of the human condition. We put a lot of faith in our ability to remember things, and the just reality seems to be that faith is pretty misplaced. Memory is not a video recorder; it's a revision process. It's a new writing. It's like a new version, a new software update every time you revisit a memory. And so it's not even the case that that going through the details is necessarily going to help people if they have a misrecollection about something. Psychologically, you're just kind of inclined to double down and remember it even harder, and maybe even remember details that didn't happen at all. But that's just the process, the ego protective process that goes on in people's heads to justify them in their worldview, and keep them safe, keep them confident in their perceptions of reality and so forth. So that's how that kind of thing can happen. Even if you think that the evidence is crystal clear, we've been sitting here watching. We've taken pages and pages of notes. We've double checked it. There's just no guarantee that each and every juror on that jury has done the same thing. And so if they haven't done that, then there is just really minimal ways to be able to resolve that. We've talked about how they're not able to go back and review the testimony. They can look at the exhibits that have been admitted, but they don't get a transcript. They don't get the testimony reread back to them. We can maybe have some feelings now about whether that is really a wise policy in this day and age, when it would not be difficult at all to do that, to produce a transcript and give it back to them, in case that is the nature of the dispute here. You know, somebody remembers something that they're adamant, that's what I heard, that's what somebody testified to, and other jurors are adamant that's absolutely not what happened. It's very difficult to resolve that type of conflict if you can't agree on just kind of what the common reality is. So might be, you know, a good indication of why that maybe isn't the best policy in this day and age. Why not let them revisit the testimony? I don't know, because historically we just never have. Is that really a good reason to keep doing that? I just don't know. I just don't know. So, don't know where we're going to go, guys. I said multiple times that in many respects in this particular case, I think a hung jury is a win for the Commonwealth. And I want to revise that somewhat, because what I really mean is it's a win for the Commonwealth if they choose to retry her. But honestly, I can see how even if they didn't, it's potentially, just given the dynamic of this trial and how it unfolded as more of a potentially as a defense of the McAlbert clan, than a real effort to prove her guilt.
All right, so I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15. So we will continue until 4:15.
Okay.
Madam Court Reporter, thank you.
So another half hour.
All right, so I'll see you at 4:15.
Court, all rise, court stands recess.
So this is positive, because it's indicating that further deliberations are helpful. They are making progress. They're making progress. That's not a terrible thing. Not a terrible thing. So where does it leave us? What if I mean, I'm not holding my breath that we're going to get a verdict by 4:15, but I wouldn't rule it out. I wouldn't rule it out, because certainly the jury is starting to think to themselves, do we want to come back next week? Would we like to be done today or not? See, it's this, I mean, as you can see, we can have all of these great ideas about coercion and outside influences and stuff like that. But juries are always going to have those things in mind anyway. How long do we really want to be here doing this? And that's always going to apply some sort of pressure on them to reach a verdict. It's just that in this framework, when it is voluntary, they are voluntarily choosing to undertake that pressure. Then it's you know, it's not likely to be any type of concern from a constitutional sort of standpoint. So yeah. So what I was saying before, I had said many times in many respects that the hung jury is a win for the Commonwealth in this case, and particularly if they retry her, because it's simply enabling them to get the pound of flesh. Use the process as the punishment, and regardless of whether Karen is ultimately found guilty or not, if she has had to pay, if she has had to suffer consequences just by virtue of being able to get through the process, that's kind of a win for the Commonwealth. You know, there's no recourse for that. And it's potentially a win if we, again, are looking at this trial structure as potentially, you know, a little bit more of a defense of the McAlbert clan than really a true effort to prove Karen guilty. Then a hung jury could potentially, you know, be seen as a win in that case as well. They were not clearly convinced of the third party culprit theory. And at least, you know, somebody is still ambiguous enough on her own role, her own, you know, possible culpability, that she doesn't get that clearance, that vindication that a not guilty would give her. It's kind of the other side of, you know, when a charge gets dismissed, okay, it's great. Everybody wants a charge to be dismissed. Everybody would like a hung jury and no retrial, because it just means it's done and you're no longer in peril. But it doesn't give you that vindication you want after you've been accused of something. And, you know, something kind of terrible, kind of immoral, you know, hitting your boyfriend and just leaving him there to die. That's a pretty gross accusation. It's very understandable why somebody would want vindication for that, and not just a détente, a white flag. We're going to walk away and not really do anything about that anymore. Philly Maniac is a member. Welcome. You know, like having some Philly Maniacs around the channel. Always a good thing to have. So I'll go ahead and look at some of your comments, guys, while we have this time. I still have some thoughts, so don't worry. Still got plenty to say about where we're at here. Dennis Jensen, I caught laid back law earlier. Your passion regarding lack of defense lawyers and the impact is why I love following your stuff. Thank you very much. This was a topic that came up on laid back law about basically decision in Oregon that said if people aren't getting assigned lawyers, they need to be released from jail. We have very similar problems going on here in my state. There is such a public defender shortage that people can't get arraigned. We have time limits on just bringing people into court to enter a simple, you know, guilty, not guilty plea, advise them of their rights and all that. They're entitled to a lawyer for that process in Washington. We don't have enough to give lawyers to everybody who is waiting to be arraigned. And so people are having to wait weeks, if not months. And that's created a very similar problem here. My point has always been, if you want to prosecute people, then you have to be prepared to fund the system and what that means. And if you're not prepared to fund it at the level that it takes to provide a fair and constitutionally adequate process, then you just need to shift your priorities on what gets prosecuted and what doesn't. So that was that conversation. Thanks so much for your comments about that. Shredder S07, Andrea, in your opinion, when one or more of the jurors hold out leading to a hung jury, should that be seen as the state failing to meet their burden? Well, it is the state failing to meet their burden. It's just not the state unanimously having been found to have not met their burden. So the presumption of innocence still attaches. It's just that the state gets another bite at the apple in terms of being able to meet their burden. I don't know that a retrial is going to benefit the defense. You know, once again, this is something that we've talked about a little bit because of all these voir dires that we had throughout the trial process. And the problem is it gives them a preview of where you're going. It gives them a dress rehearsal, a test run at being able to handle you. So barring some major switch in theory and emphasis and where you go with these witnesses, They've been able to practice, and it's just, you can kind of assume when you have an opportunity to practice something, you're gonna do it better the second time. So yeah, they didn't meet their burden, but they didn't unanimously fail to meet their burden such that that there needs to be an acquittal. Theory neutral, 3:28 p.m. EST. Thank God you went live, Andrea. Well, I'm not going to say that, you know, I didn't have my notifications blowing up and stuff like that. But so I do apologize, guys. But I did want to take the time to make sure I'm caught up on exactly what happened, what was said, and then look into some of those implications so that I could give you guys a little bit of guidance about what to expect, what the process will look like, what this all, you know, means in terms of the legal framework. So we're not at a point yet of ruling out that they're going to reach a verdict. It is possible. It is possible. They could decide, look, we ain't coming back Monday. No way, no how. So one way or another, things could get resolved still. I am me. The jury should remain deadlocked long enough to mess up Bev's vacation plans. Wouldn't it be curious? I mean, maybe not. It's just a coincidence of timing. You know, if the jury remains deadlocked, and it's only at that point where we're on the eve of the July 4th holiday that suddenly we can decide this is due and thorough deliberations at this point in time. That would be pretty coincidental, but also likely within her discretion as the judge. Rube, jurors say exhaustive and deliberate. Bev says that's not due and thorough. Sounds the same to me. How do jurors know there are magic words? It's not really about the jurors knowing there are magic words as much as the fact that the judge doesn't have to take the jurors' words for it, at least not at this point. She should respect them, but at the same time now, they're continuing. They're asking for more time to be able to continue. This is kind of validating her determination that no, they hadn't actually exhausted everything. They were probably frustrated and, you know, trying to, I don't know, be nice to each other or something, maintain some collegiality. But the reality is sometimes the jury room does have to get heated. I mean, it just does. Sometimes it does. If people are plainly not being reasonable, then, you know, you can politely, well, I disagree, you know, inevitably, but the argument is maybe at some point you have a duty to lean on them and say, hey, motherfucker, you're being completely unreasonable here. And here is all the reasons why. So I don't know that there are magic words that they could have used that would have really changed that determination from earlier in the day. It's just she has the ability to substitute her judgment for theirs, and she's done that in this case. AKA the cat lady. This is Bev's second hung jury in a row. Does that tell you anything? It doesn't really tell me anything, just at least not as far as Bev is concerned, because she doesn't really have control over why the jury would be hung. I think, you know, in most cases, it's going to be because they are in conflict about what the facts are. And if they're in conflict about what the facts are, that's squarely on the feet of the Commonwealth. The Commonwealth has failed to establish facts that would satisfy everybody on the jury beyond a reasonable doubt that they know what happened. And so my perception of what's probably going on here, you know, I'm not mind reading. I'm just trying to read into the situation as best as I can, given the whole question we already had about the cert report, them wanting to take a look at that. I really do think it's coming down to conflict between do we believe that the police were involved in fabricating the evidence, or do we not? Because the timing of those taillight fragments, that is part of the challenge of Karen Reed. It would be very hard for a jury to think if her pieces of her taillight were there at the scene the same day as the accident, after she had left. How did they get there? You know, if not from hitting John O'Keefe. And if somebody is really resistant to the idea that law enforcement could have planted those, then you're pretty much stuck with the conclusion that there was some kind of incident there. So I think it's very possible that the taillight is really the crux of the factual dispute here. If it was a frame job, that's why it was very effective. That's why it was very effective. And if it was not a frame job, then, you know, that's why it's a tough sell. That's why the frame job is a tough sell. The timing is a challenge. So again, just going back to how attentive the jurors are, what their just kind of presuppositions are coming into the case. You know, if they didn't hear enough to convince them, yeah, the police probably planted it, then they're going to be thinking, well, it's there, it fit her taillight, it's there because there was some incident, and the some incident was probably her hitting John. What else did she hit? This is always the challenge and the very high risk strategy of doing the third party culprit, which we've talked about too. You just run the risk that the jury sees their choice as binary. We believe the Commonwealth or we believe the defense. Who has proved what? And that has the unfortunate tendency to suggest that you, the defense, have a burden of proof. It takes away some of that pressure that's otherwise squarely put on the Commonwealth to establish, you know, it's their version of events or nothing. The challenge with this particular case, though, again, because it comes down to those taillight pieces and what they were doing there, you know, on the evening of January 29th. It's very difficult to explain that without putting it on law enforcement, putting it on the investigators. You know, once it matched up to the taillight, once they have testimony from somebody who says, you know, these are the specific things that we found, here's photographs of them, here's where they ended up in the reconstructed taillight. Really makes it look like like it's hers, and then that's just a hard fact to be able to overcome. So it's not that they have a burden of proof to give an alternative explanation for how the things got there, but just as a practical matter, you can kind of understand, at least I can kind of understand, how a jury that has not bought into a law enforcement cover-up, a frame job, they don't have a whole lot of other explanations for how it could have gotten there. It's just part of the high risk, but I'm just not entirely sure, given the facts here, that they really had any other alternative. I do still wonder, because I'm still not sure. I don't know if 47 pieces of taillight made it back into that reconstructed one. You know, was there more taillight here? I would like more provenance about these taillight pieces and the photographs, you know, that show the searches being conducted and so forth. I guess just some verification to be sure, yes, these are the actual pieces that were found on these actual dates, and not just we found some plastic and then at some point everything ended up in the unsecured room at the Norfolk County DA's office, where it can all be mixed and matched and put in the appropriate bags, and they can decide which ones the CERT team found. That would go a long way if they could, you know, towards just narrowing those options and making it making it just more difficult to explain away without the law enforcement involvement. It's just a very tough hurdle to overcome. Otherwise, getting people to believe that that the police manufactured it. It's very tough. Law Gal, they are back in the courtroom and are sending the jury a note asking their status. Yeah, so we've seen that. That is generally going to be okay. How you doing, guys? Everything okay? As long as you're not putting pressure on them or like, have you reached a verdict yet? Definitely can't do that. Definitely can't do that. But under the circumstances, that's probably not going to be any type of problem. KB, a potential windfall for Netflix. Hung jury retrial, 2 seasons. Yeah, an epilogue, a sequel, a part 2. Not great news for Karen and her team. I mean, it's just not great news. It would be devastating. You always do the best you can in a trial, but there are so many judgment calls you have to make along the way, and it's hard not to just have the hindsight bias and really second guess some of those judgments. And one of the biggest ones that is really hard to not second guess is, should I have testified? Would that have made a difference? Should I have testified? I really hope that Karen is not beating herself up over that decision because it's done. There's no undoing it. The best thing you can do is, if you do get retried, give it independent thought and try to be as objective as you can about it. But she's going to remember if they have to retry this case, and she chose not to testify, and she is wondering right now, would that have made a difference? Hard not to think that isn't going to affect the decisions that they make in a second trial. Amica Cream is a YouTube member. Welcome, Amica Cream. We might all need it a little bit today. We're feeling a bit chapped by this jury. Kirsty, Haas long until we can stop looking at the fan. We've been, all of us, staring at the fan like all day. It's been up on our little side screen. I would love to be done staring at the fan too. Patience. Hopefully we'll get there. And Amica Cream has also gifted 5 memberships. Well, thank you so much. Thank you for that. That will be a balm on some of our souls. Duncan, Idaho, wouldn't retrial be worse financially for Karen Read, but better for her case? Seems like it'd be a great opportunity to catch Commonwealth witnesses lying in new ways that can easily be impeached, weakening the Commonwealth's case. This is a factor that favors the defense, certainly. The fact that everybody is now on record, it's just another time now that they can be tied down to what they said before, so they have to stick with it. And if they deviate from it, then you have the ability to come back and point to, this isn't what you told the jury the last time. So it gives them that advantage in the sense that they can, knowing now what those answers have been, they can potentially adjust their strategy. They can adjust their theory. They can think of just alternate ways to potentially be able to attack the information, the evidence that's been put out there. The question always comes down to, how meaningful is that to the jury, though? Do they see this as nitpicking at details, or do they see them as substantive changes? It can really cut both ways. Obviously, if they completely switch course and come up with a whole different stories, now suddenly Higgins parked in the driveway or something, that is probably going to benefit the defense. But it also depends on their explanation, because anytime you impeach somebody with a prior inconsistent statement, it's part of the foundation. You have to give them an opportunity to explain it. And their explanation can always be, I remembered. I forgot before. I was wrong, but I didn't remember, and now I do. And you can't forget too, these people are shameless. They're shameless. They'll lie to your face. So coming up with some excuse for why they would change their story, I don't see that being a problem. You know, not from any type of internal moral clock, moral compass kind of sense. So how helpful that would be, I'm just not entirely sure. And yeah, just when you consider the financial and it isn't just the financial cost, you know, it is the psychological cost. It's going to be a big blow. You put everything at this. Alan Jackson gave the closing argument of a lifetime. You know, if you're going with the Karen Read was framed theory, I just don't know how better he could have done at nailing that. So yeah, it's a tough one. If that's how this ends up going, it's tough. Kayla Howell, if she is found not guilty, can they get attorney fees? Nope. 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 She gets her freedom, and she gets her busted up car back, and that's what she gets. The cost of defending yourself and going through a prosecution, it's on you. It's on you. There's always, to some extent, you know, at least there would be in this circumstance, the potential for her to try to recoup some of her costs through a civil rights type of claim. That exists here because we've got these indications of fabricating evidence, falsifying, things like that, that would pretty clearly support a claim like that. But most of the time, you don't have that option. Nope. Nope. You get to go back to your life, or what's left of it, and that's what you get as the result of acquittal. You get a broken life back. Sonam Lama. I think it was a mistake not to put Karen Read on the stand. For me personally, I needed to hear her say she didn't do it. This is always a tough call, and I recognize the common wisdom. I've recognized it throughout. If you don't have to, it makes sense not to, but this is also why, everything else being equal, if I can and it won't take my case, I want to do it. Because yes, the jury is told they can't hold it against her, but the jury is human and they want to know. They want to hear from her. And I've said so many times, the jury can be so forgiving, even of, you know, things that you did wrong, things that you concede. You know, she might have to get on the stand if she's being completely honest and concede, yeah, I had several drinks that night when I drove, and looking back on it today, perhaps I shouldn't have. Perhaps I, you know, wasn't at my best in Aruba. Maybe I wasn't at my best when I was, you know, doing this little flirtatious game with Higgins. These are things I'm not proud of. We've seen all of the Commonwealth's witnesses have to do that. And yet, apparently, at least someone on the jury is not really holding that against them, you know? So I do tend to think the jury can be quite forgiving of a lot of those kinds of explanations if they hear them. And if they hear something that strikes them as authentic, whether it's good or bad, then they're going to trust you. So it's not about, are you a good person? Are you a bad person? It's really, I think, about getting a feel of just, are you real? Are you up here pretending? Is your denial of responsibility fake, or do you sincerely believe it? And so even if there are other bad things you have to admit along the way, if you can sincerely testify, I didn't do this, it just goes a long way. I don't want to second guess that decision because it is the common wisdom, you know, but I certainly would have liked to have seen her testify as well. Sandy McPartlin, does hung jury affect Karen Reed lawsuit? Not really. Not really. I mean, they're different burdens, and her ability to sue Proctor, to sue Canton Police, to sue Massachusetts State Police, they're not parties to this case. So there's nothing about this criminal case that would be binding in any way on a future civil jury or a civil judge. They would have, regardless of what happens here, the ability to argue no qualified immunity applies, no factually that isn't what happened, you can't meet your burden of proof. All of those things would still be at stake in a civil trial. I think the real issue here is, number one, the effect on the war chest, because a civil lawsuit is out of her own pocket. You don't have like an insurance company, come in and sue for you. They're there to defend you. So if she is now contemplating maybe having to pay for another criminal defense, another trial defense, that's going to affect your war chest pretty substantially. But the other piece is just the moral shot in the arm you get. You get from the win. You feel the vindication. You were able to convince the jury of this very high standard, under this very high standard, beyond a reasonable doubt. They didn't believe you hit John with the car. If you can prove it to them to that level, then you're going to have a lot more confidence in your ability to prove it to them by a much lower standard, a preponderance of the evidence standard that you were framed by this police activity, this unlawful police activity. So it doesn't mean she can't still. It's still a lower burden. But yeah, I think that the practical effect is really just, can she pay for it? Can she pay for it? Stephen Bunt, how come a hung jury doesn't double jeopardy? Is there a history of or high amount of hung cases that get retried and get convictions? So statistically, I don't know how that breaks down. I really don't. I mean, I can say that it happens. Yeah, it happens. Jury hangs and you go back and you retry it and they convict the second time. I've had a few appeals where that's been the context, and boy, those are kind of annoying, because then I got to read 2 trial transcripts. I got to go through the first trial and then go through the second trial and think about how they all connect together and so forth. So it definitely does happen. But the reason why double jeopardy isn't implicated is because double jeopardy is only implicated by the acquittal. If they don't acquit and there isn't some kind of prosecutorial misconduct that necessitates a mistrial, that like renders the process so unfair that it can't possibly continue, then jeopardy doesn't bar it. There hasn't been an acquittal, so they're allowed to go back and try again. What they're not allowed to do is poison the well so that, an acquittal or a verdict couldn't be reached, and then take advantage of that to be able to go back, or to poison the well so that the defense has to ask for a mistrial because, something so egregious happened that they can't possibly continue with this verdict. The prosecution cannot, what's the word I'm looking for here? They can't provoke a mistrial and then benefit from that to get a second bite at the apple. But other than that, if it's just the jury trying to evaluate the evidence, can't decide guilty or innocent, then there's no acquittal, so no double jeopardy problem. Kevin, I bet why guilty must be unanimous, but not guilty, in my view, shouldn't have to be. Yeah, that's a tough one. It's a tough one. I understand the preference. I mean, certainly beyond a reasonable doubt to convict. Yes, we need to have a unanimous verdict. To acquit, because of the way that it operates as something of a vindication, I can kind of see why you would want a unanimous jury verdict for that as well. But I definitely see the point that, look, a non-verdict for the prosecution means they didn't meet their burden. They weren't able to convince 12 people beyond a reasonable doubt that she did it. And how many times should they be allowed to drag her through in order to try to get that result? Because under the law as it exists, there really is no limitation. There's not. They could keep trying over and over and over and over and over again, and as long as the trials are okay, there's nothing out there at this point in time that says they're barred from trying yet again. So I definitely see I see both sides of this one. Palmyra Productions is gifted 5 memberships. Thank you so much. Thank you for those 5 people as well. Melinderp, what is the reasoning on why presumed innocence doesn't mean acquittal with a hung jury? Just because it's not a unanimous agreement that the Commonwealth failed to meet their burden. Some people think they did. Some people on the jury think the Commonwealth met their burden. And so that's just how we have it. That's just how we have it. The decision that they have not met their burden has to be unanimous just as much as the decision that they have. Still Raven, it takes just 1 second to take your freedom on probable cause and years to prove your innocence in a system where you are presumed innocent. This is what I mean when I say the process is often the punishment. And, you know, the government can get its pound of flesh. It can get its vengeance, its malice. It can inflict that on you, frankly, even if it gets an acquittal, you know, even if it goes to trial and it gets spanked by the jury, you have still suffered through that process. If you are not Karen Reed and have the resources to be able to, you know, post bail, hire an attorney who has time to work through all of these details in your case, look at these fine minutia, figure out how to present that to the jury, let it simmer what the best arguments are going to be and so forth. You're just in such a different standpoint, such a different position. And it shouldn't be that way. It shouldn't be that way. I know that there's this whole it's unfortunate that criminal justice reform has become so politicized, because that's made it polarized. You know, it just throws it back into this partisan system where you kind of have extremists on both sides that are playing winner takes all, you know, with the criminal justice system. And it's unfortunate because I really do think there's so much common ground on a lot of these problems that everybody can agree on. But it's just that when you have a scenario where, like, for example, I feel like most people recognize that being held in jail when you have not been committed of any crime, when you should be presumed innocent, that should generally not be okay. And I know that a lot of people that were watching, like, the January 6th prosecutions, this was very revelatory to them to see how much that was happening. I'll come back to this thought once we see what we're getting from Judge Bev here.
Closing session, please be seated.
All right. So jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh on Monday. So please follow those instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it. We'll see you later. Thank you.
All rise for the court, please. Jurors, follow me.
Back on Monday. Their goal was to get done over the weekend, or before the weekend. Yeah, didn't happen. So the whole take the weekend to kind of rest and clear
All
your
right.
minds.
We'll see you Monday morning. Thank you.
Thank you, Your Honor.
And come back fresh on Monday. This, from my perspective, would make it harder if they still can't reach a decision on Monday, to continue sending them back. If they come back in on Monday and they put in a couple hours and they're not getting anywhere, that's going to be a problem. That's going to be a problem. But hopefully they didn't come back to the court with any further, no more note, no more indication that, hey, we're stuck, we're not getting anywhere. So hopefully this is an indication they've been able to make progress, and maybe the weekend will help. So just to come back to this, I feel like the January 6th prosecution opened a lot of people's eyes to the reality of what a lot of people who are probably not your political allies have been living under, for decades. Like, this is the system. This is the system. Welcome to it. So there's a lot of common ground here in being able to recognize problems and come up with reasonable solutions to them. But the problem is just that it becomes polarized. And so, on the one hand, you have people being held for, years. We got Richard Allen in Delphi being held in prison in solitary confinement for almost 2 years now without having been convicted of any kind of a crime. And then on the other hand, you have the abolishment of cash bail, where absolutely nobody gets held for any circumstance at all, including, extremely violent, dangerous people. There's a middle ground here, okay? I'm pretty sure reasonable people could all recognize there are some situations, there are some people where, yes, there is enough of a risk, enough of a concern here that, there is justification to impose some kind of bail, some kind of assurance that gives them skin in the game to keep their nose clean and participate in the process. But just because it's been captured by this political process, it becomes a thing of extremes. You're either in favor of abolishing cash bail and letting everybody out on the streets, or you want to incarcerate everybody in prison, without any kind of a sentence. And it just I don't know. It speaks to the brokenness of the political process that we have, to my mind. But yes, that is exactly why this is such a problem, because yes, cops can be wrong. Cops can be wrong. They can have the wrong person. They can misunderstand what's happened. They can, for whatever reason, in the course of this engagement with you, develop a grievance and decide you're going to pay for it for some reason. There's just a massive amount of power that comes with the ability to charge people. And yeah, there are consequences for that regardless of what the outcome ends up being. Singing Ferret. I once was on a jury where we had this issue where we did not agree on some of the charges and the judge sent us away again, and 2 hours later we came to a verdict. Yeah, it does happen. It definitely does happen. I mean, I've certainly seen it happen before. And maybe, it is just a little bit of a nudge to maybe stop being so nice to each other. Maybe challenge each other a little bit more, put your politeness to some extent aside. Like, I'm not saying, be rude to people. Like, don't throw down in the jury room. That's not what we're talking about. Like, we're not going to resolve it by fisticuffs. That would be a problem. That is jury misconduct. Violence or threatening violence to change someone's vote. Yeah, that's misconduct. Don't do that. But just in the sense of maybe you've been overly deferential to people, and it's time to have hard conversations. A lot of people aren't inclined to do that if they don't have to, so it puts pressure on them to maybe just be a little bit more direct. Cargo pilot guy, hot take: unanimity should only be required for a guilty verdict. Not guilty should be able to be decided by a simple majority of jurors. I can definitely see this. If the majority haven't been convinced beyond a reasonable doubt, then that seems that seems like a pretty significant failure on the part of the Commonwealth. And it seems to be a situation that would kind of, I don't want to say impeach, but because it's a different context, but just to overcome that grand jury determination that there was enough to go forward here. Once you have gotten to trial and you've gotten the whole picture, including the defense's case, including the defense's ability to challenge the prosecution's case, and you can't get a majority, maybe you shouldn't be allowed to go forward anymore. I can definitely see this argument. Karen Duffy, what's to discuss? Science, physics, kinetics, math, and all the stuff clearly shows the flippin' car didn't hit him. They cannot even say she was drunk. In all certainty, she wasn't tested at the time. To me, it seems pretty clear. It does, but I paid attention throughout this entire thing, and I came in without a real heavy skepticism against this idea that she was framed. You know, if I had come in with more deference to law enforcement and to what they have to say, I don't know. I honestly just don't know. I want to try to be fair to everybody and everybody's perspective. I realize it doesn't make sense to me. And yes, to me, I believe the FBI guys. I believe the forensic scientists, the pathologists. You know, this is a dog bite. This is a dog bite on his arm. And her car did not hit him and throw him, didn't cause this type of impact. I just think the problem continues to come down to those pieces of taillight at the scene. And if they haven't convinced the jury, if they didn't convince the jury that those taillight pieces were there because police officers put them there, then the alternative is those pieces are there. At least the logical, conclusion seems to be those pieces are there because they came off of Karen's taillight there. And maybe even if it wasn't as bad as the damage ultimately ended up being, maybe if the collision, the Commonwealth hasn't even explained to us exactly how everything went down. She tapped him just hard enough to break, or maybe she tapped the glass, and it was just hard enough to break the taillight, and it didn't like hit him, but he's drunk. He's very drunk. This man is very drunk, and he lost his balance and cracked his head. I'm not saying it's right. It's not how I would think through the case, but I can see a scenario. I can try to put myself in the shoes of somebody who is having difficulty with this verdict and see ways that I can sympathize with. Let me just leave it at that. James Brown, I didn't know Selectman McAlbert served 6 months in prison for DUI resulting in death, and Karen Reed bailed John out for a DUI, many problems with alcohol. The alcohol all over this case, it really is a mess, isn't it? It really is a mess. Just everybody driving drunk, and Karen's the one who has consequences for that. Yeah, who was it? Was it Chris Albert? Chris Albert had the hit and run where somebody died. I think I had heard about that, and then I'd also heard, I'm not sure if it's a rumor or confirmed, that Judge Bev's brother had represented him. That was one of the concerns people had about Judge Bev's impartiality. I got to tell you straight up, I'm not sure that having a client relationship with somebody would necessarily automatically put them on your side. It's going to depend on the client. It's going to depend on the client. There's plenty that, you learn through the relationship. How much weight to put on what they tell you versus what the evidence is going to show. Great Kate, a guilty verdict equals low standards for policing. Easy to see in Canton. It's the piece that's kind of behind all of this, right? The fear and just the us versus them. You know, they have done everything they can, I think, to frame this as us versus them. Them being, I mean, the McAlberts, all the way up to that showing up with the O'Keefe family for the closing arguments. It's us or it's them. And even if jurors don't have connections with any of these people already, they can see the writing on the wall. They can understand, if I vote this way, I've got a new powerful friend. If I vote this way, I might have a powerful enemy. You really can't rule that out. You really can't. It's unfortunate, but it's just part of the decision-making process that I'm not sure you'd be able to flesh out in jury selection without getting into some kind of, you know, deep personality level stuff that would let you predict who would likely to be thinking along those kinds of lines and engaging in those types of decision-making processes. Go Georgia. If taillight is primary evidence, Proctor's fate with FBI investigation may see real justice. We have to wonder what else the FBI has that they haven't already given the parties. They've got a good circumstantial case, but no direct evidence. Right? No direct evidence. Nobody caught him doing it. Nobody's flipped and said he did it. He just had opportunity. And he had motive. If we buy the, you know, longtime family friend of this family. But as far as proving he actually did it, unless they found that Canton Sallyport video, that missing video. Gotta wonder. Charles Argo, what if the taillight was cracked when she hit John's car and the parts fell on the road when she got to John's body in the morning? This would require her to have done that second trip back, because when they went back and found him at 6 o'clock, remember, her car was at John's. They were in Carrie's car. They weren't in her car. So if she went back to Fairview Road at 5 in the morning or whatever, then that could potentially work. It's still going to be a tough sell to the jury, right? Coincidence. Pretty good coincidence that that's how it happened. And I just don't know if it would get over that hurdle. I don't know if they would consider that a reasonable alternative explanation or not. Some people probably would, but if what we already have hasn't convinced at least one juror, I'm not sure that explanation would. Just Because is gifted 5 memberships. Thank you so much. Thanks for everybody who gets to be a member today. Red Forensic, did the defense ever ask where's all the blood, and how could jury not see the intact taillight in the John O'Keefe driveway? It's amazing what people cannot see when they're really motivated to not see it, and vice versa. It's just amazing what the mind can do, how much the mind can control your perception of what it is you're actually seeing. The taillight is cracked just enough that there is some flaw in the taillight. But a jury who really wants to see something more than that, they're going to be able to see, well, look, there's a crack in this other red. That's just reflection. That's just glow from the other parts of the taillight that weren't affected. People are going to have a remarkable ability to come up with explanations to justify why in their mind they see what they want to see. Where's all the blood is always a question I was kind of wondering about. And I don't know. I don't know. It's possible that there isn't a good answer to that question. The answer would be, well, the blood would have been mixed up in the dirt and in the snow, and so it's just not a good likelihood that it would have been noticed or recovered. I don't know. I really don't. If his head is down there on bare grass, like Carrie Roberts told us, right? He's on bare grass, and he would have to be to fit the timeline with what we saw outside the library. If his head is on bare grass, then yeah, the blood is going onto the ground. I'm not sure that it would be visible. I don't know if it would freeze. I don't know if it would seep. I would assume at some point it would seep into the ground. And I just don't know if there would be good visible indicators of it being there after it gets all the snow falling on it, and then the melt thaw process and all that. But they also didn't emphasize that he was on top of the snow. That to me was always a very strong point in the case. Look at the library video. Look at what the conditions were when this accident was supposed to happen. And then look at the photographs they were taking no later than 7:45 in the morning, right? Because that's about when they left. And you can see in the photos, it's very early morning. It's just starting to get light enough to even be able to take photos. And where's the bare ground that he's lying on? There's none. There's none. He was on snow. He was on snow. I saw somebody. It was interesting. It's not a forensic process. I don't think. I don't think it would qualify. But it was nevertheless, I thought, pretty intriguing. Somebody had taken one of those, taken a still shot from the leaf blower video and tweaked the color, right? If you change the color and the saturation and stuff like that, you can just pull out different details of the photo of what's captured in the digital image compared to, just your standard kind of processing where the snow is very overexposed and hard to get detail and things like that. And that photo sure did make it look like there were footprints leading away from that compacted area, where they were blowing the snow. Now, there were a lot of feet around when John was getting treated. A lot of people coming on the scene, running around frantically, all that. But that was just kind of always an issue for me. It just doesn't make sense with the timeline. The fact that there's no snow at 12:30, and here he is on top of all the snow the next morning. But that didn't get brought up either. Tim Harris, say it is a hung jury and the Commonwealth says you're right and indicts the 10 adults, 6 teenagers, and several policemen. As a defense lawyer, would your advocacy switch over to them? Serious question, though. Good question. I would certainly advocate that they're entitled to the presumption of innocence, just like everybody else. They get the benefit of the doubt. They're entitled to their process and to let it play out. But then we're going to judge the evidence. And if the evidence is no different than what we've seen here, I don't have really, a lot of confidence. Well, let me put it this way. I'm not sure that the Commonwealth would be able to prove who did what, right? I think this is part of the big problem that they have. They don't know. They have a lot of people acting really shady. They have circumstances where it looks like several people could have been involved. But would the Commonwealth be able to meet their burden of proof to establish, any one of these people killed John O'Keefe on the evidence that we've already seen? I don't know that they would. I don't know that they would. So, I mean, yeah, the burden of proof, it does go both ways. It does go both ways, and they would get the benefit of that in my eyes. So, yeah, I don't know that I would say they've been proven beyond a reasonable doubt in my mind. I couldn't say, yes, Colin did it. I don't think that's been proven. I can't say, yes, I think Brian Higgins did it. To me, that's the most logical explanation, is Higgins. He's the one that had the motive. But have they proven it? Not on this. Not on this. But if these people got charged, then that's going to open the door to things like, why don't we get their swab and see if we can compare it to some of those mixed samples all over John's clothes. It would open up new investigative pathways, a lot more digital investigation and stuff like that. And so if that could contribute to the case and potentially answer some of those questions, then I think that's what the tipping point would be for me, is really if they were able to do that. If it's just what we have, no, I don't think they have. I don't think they have. Not in my mind. Solo cup evidence. They shouldn't pick foreman before the alternates. Bad look. I love your big brain. You're one of the top 2 favorites. Thanks, Andrea, for the knowledge. Well, thank you for the nice compliment. I appreciate that. It was a bad look. It was a bad look. I really didn't understand that at all. Because it tells me that you kind of have to have fixed the draw, right? You have to have fixed it. If you've picked the foreman, then you have to pull the foreman out of the draw. Or what? What if you draw the foreman? Do you just, whoops, never mind, mulligan? I mean, it's just, no, it's not a good look. I agree completely that if they're going to do a system where the alternates are randomly selected and the judge gets to choose the foreman, you need to pick the alternates first. To me, that just seems very logical, but it was a very, very strange process. The Squid. The anti-Karen Reed people on Twitter have resorted to faking a video implying that Karen and Jackson have some kind of improper relationship with each other. Truly disgusting behavior. I saw the video. I really don't have anything to say about it. It has no provenance. It's a small clip. Where is the person who is, claiming to have taken it? Where's the rest of the video? We've already seen, clipped videos throughout the course of this trial that are modified to create impressions that are not real. And yeah, that's really all I'm going to say about it. If Alan Jackson and or Karen Reed have anything to say about it, I'll pay attention to that. But just this thing floating out there doesn't really have any significance to me at all. Sonam Lama, don't think the retrial will help without a new judge and new venue. A new venue is a good, that's a good call. I don't know if they tried to change venue in this case, did they? I would think that they probably did. Like, this is not going to be a problem that, not going to be a problem that they hadn't contemplated, just given their whole theory that, this is an issue with the power that these folks have in the town. I mean, if they're so powerful that they can get law enforcement to cover up for them, then yeah, you should be anticipating that this venue could be a problem. I don't remember off the top of my head seeing it though. I don't know if they did, but might be worth considering. We do know they tried to get the judge off of it, but that failed. That failed. So unless some new basis comes up to try to, get her disqualified, it's up to her. It's up to her and just their process there in that county. If it's assigned to her and their rules say that's that, and you follow it through to the end, then that's what's going to happen. Vicky McNamara, thanks to you and Jeff for your time and effort with this trial. Plus, I love this chat. Such a fun group. If I ever need an attorney, I can only hope it's someone like you. Much love from Texas. Well, thank you, Vicky. And really, really appreciate that. I really enjoy this chat too. Really like these comments. I'd love to be able to, participate in the live stuff, just the regular chat a little bit more, but lot going on. Focus on this, focus on that. Think, talk. I got limits on how much I can divide my attention. But every time I do get a chance to peek in, it looks like folks are having a great time. And it's important to me. I've said before, I want to have a free speech friendly place here. This is not supposed to be an echo chamber. You can disagree with me. I have no problem with that at all. I kind of like when people disagree with me, because that's challenging. That stimulates you intellectually. It just needs to be done with respect and with some basic courtesy. That's all. So thank you very much for that great comment. Z, can dismiss with prejudice based on exculpatory evidence. Not really, because the judge can't be, she's not allowed to substitute her view of the evidence for the jury. She's not allowed to weigh the evidence independently and decide what she thinks the outcome should be and then make that happen as a matter of law. And that's right. That is the right outcome, because you got to think about the cases where you wouldn't want them to have that discretion. Just because it seems like that might be a fair outcome here, you can imagine all kinds of situations where a judge, for whatever reason, if they have the power to usurp the jury's role and make the decision themselves, that could be a pretty tyrannical position for that judge to be in. In J. Kathy, would Judge Bev hear the retrial? More than likely, yes, she would, unless she decides, hey, people retire, people get different jobs, people get appointed to the appellate bench. I mean, things definitely happen. So something like that could get her kicked off the case. But otherwise, typically, yeah, it's going to be the same judge. They prefer judicial efficiency. They don't like to have to decide the same things over and over again. This judge is already familiar with the case. She's already familiar with the pretrial rulings. A new judge is going to have to get up to speed. They're maybe going to disagree with some of those, parameters that have already been set. So it just complicates things to reassign it to a new judge. They prefer to keep it simple. Pupperski, can KR ask for a different court region? If she has not already moved to change venue, then I would expect she would be able to do so. It's a tough call, being able to change venue. You have to show you can't get a fair and impartial jury in this one. And Canton is not, it's not the whole county. Norfolk County is more than Canton. So even if we start from the standpoint of like, well, you can't get anybody fair from Canton because the McAlberts rule that place, there's still people from outside that area that would be in your pool that you'd potentially be able to draw from. Beyond that, the biggest chance they could potentially have for getting a change of venue would be the trial publicity. I have to assume this has been national news. It's had to have been a big deal in the local area. So if there has been so much coverage of it at this point that it's kind of pervaded the community and people have, formed fixed opinions about it based on what they already saw at this trial, that could make it harder, to pick a jury a second time around that doesn't know anything about it, hasn't already prejudged it, and that type of thing. But that can be hard to prove. We're seeing in Koberger the lengths they're having to go to look at the effect of the media coverage in the area. It's going to cost a lot of money to do that, and there's no guarantee it's going to give you a big return. So, for her to choose to go down that road, that would be a big investment. Maybe they would consider it to be worth it. I don't know. Otherwise, typically what happens is they're stuck with just going into jury selection and trying to deal with it during voir dire, trying to suss out the extent of the media taint. And so it's common to ask for a change of venue at that point in time, not do it way ahead of time. You just wait until you see what panel you have. And if it's clear they can't be fair and impartial, then you ask to move it somewhere where they can be. Karen Duffy, if HJ, could she make money via media interviews? Hung jury. Yes. I mean, she could anyway. It's just, would that be prudent? Would that be prudent? Generally not the best idea to try your case in the media, try to defend yourself in the media, as I suspect in the coming weeks, Alec Baldwin may learn. Not generally a good idea. But nothing against the law. prohibiting her from doing it. There's no gag order in this case, and she's not subject to the same kinds of ethical constraints that the attorneys are. The attorneys are limited in their ability to advocate about the case in the press because they have the duty to try to preserve the jury pool, the fairness of the jury pool, not taint them, not introduce things that would unfairly affect the ability of the case to be fairly tried. But Karen's not a lawyer. She's not subject to those rules. So she could, in theory, but I would have to think she is being strongly advised not to do that. Arla7247, think Turtle Boy a pro or con? It's hard not to look at the crowds and the enthusiasm that he has been able to bring out in this case, and then also just look at the polls. Polls on places like the Court TV and Law and Crime, where we're not a uniform audience. We haven't all kind of gathered together because we tend to share the same perspective on the case, right? It's not an echo chamber. Just this overwhelming perception that, if they were voting on the jury, it would be a not guilty vote. It's hard not to look at those things and credit him in large part for that. But I also understand this perspective that the other side of that is the backlash. It's something I have quite a lot of ambivalence about, to be very honest with you. I don't have a real, clear feeling one way or another about Turtle Boy, because if I was representing somebody who I thought was innocent, I can see why something like this would be validating and vindicating, and it would help your client, help keep their head up, keep their hopes up, all of that type of thing. But I can also see the potential for the downside, the just general, distaste that people of perhaps a more conservative mindset are not going to see this as appropriate. That it's just a trial isn't the type of thing to protest about. It's not the type of thing to be an activist about. It's supposed to be dignified and let the process work out and so forth. So I can see it as being a situation where, yeah, there's a risk that there's backlash, that people respond to this movement that they don't like, and they would hold that against Karen. It's just another situation of kind of a high risk, high reward type of situation. But it can backfire. I don't know if it did. I don't know if that's the situation, but I can certainly see the concern. The Manson cases, Haas long for hung jury or acquittal. Kidding. Probably Monday at this point. Probably Monday or Tuesday. I mean, it seems like the jury is going to come back after the weekend, and they're either going to continue to make progress or not. And I would think they would be able to recognize that pretty early on. If they continue to make progress, then maybe they'll just, they'll stay at it until they can't anymore. Maybe they'll be able to work it out. I don't know. But at this point, early next week is looking increasingly likely. Nathan C. Under Rodriguez, she can't send back more than twice. Yeah, so we talked about this at the head of the show. The issue is that Rodriguez applies after due and thorough deliberations, and she specifically made the finding, and this is exactly why she made the finding, that they have not engaged in due and thorough deliberations at this point in time. So that statute has not been triggered. The need to give the Tui Rodriguez instruction has not been triggered. And under the case law in Massachusetts, she has a lot of discretion to be able to make that determination, looking at what's the complexity of the case, the number of issues they likely have to resolve, the amount of time that they've spent on the deliberations. Very unlikely that her determination there would be second guessed. So they're not yet at the point where we're counting. My suspicion is that if they come back again, especially after the weekend, and say, look, we tried, but we're just not getting anywhere, that's the point where, okay, she's going to have to give them the instruction. And, if she doesn't just go ahead and accept it at that point in time, which she could as well, she doesn't have to send them back to keep trying. It's just an option that she has. But if she did, that's when this limitation would be triggered, where you need to give that instruction and you only get one shot. Because after that, if they come back and they still can't agree, you're done. Zulu 11, this is cruel and unusual punishment for us. The limbo is the worst part. It's the worst part of every case. It's just, it's excruciating. I feel so much for Karen and for her whole team, and for the O'Keefes as well. Everybody wants closure, and the longer you wait, especially with something like, the specter of a hung jury in the ether there, it's just the closure is further and further from your grasp, and that is very difficult. Palmyra Productions. Karen was definitely staring down one of the jurors. She was looking directly at someone. It wasn't the jury itself. That stare. I did see her staring pretty closely over in that direction. I do wonder if she has an idea of what's going on. She's got an impression of the jurors. She's had a lot of time to watch them, see how they react, get a sense of even just how they feel about her. If she has, I don't know that a stare down, like an aggressive type of confrontation, is really, really the way to go. But she's gonna do what she feels that she needs to do, what is authentic to her. And what will be, will be. WM Penguin. Hold on, we aren't allowed dueling pistols in the jury room. What's even the point anymore? Yeah, back in the old days when they could just go ahead and put the jury on the wheel, break them, start to stretch them out until they decide, all right, not guilty. Oh, for the good old days. Yeah. No more coercion. So trials are, in some respects, I guess, probably less exciting back there in the deliberation room. Arla 7247, maybe question the idea police aren't honest too much to accept. If you can't have faith in your police, what can you trust? Very strong incentive for people for just self-preservation, feeling of safety purposes, to believe that the police are there to help them. Police are there to keep them safe. Police are being honest, because the alternative is difficult to contemplate. That would, I think, make most people feel unsafe. And it would challenge potentially a lot of assumptions that you have about the world that you live in and the things that you can take for granted, and just a lot like that. So that would be difficult as a juror if you come in with those types of presuppositions. Yeah, you don't want to let them go. You don't want to let them go. And even if it looks an awful lot like the police might have done something dirty in this case, you're going to want to resist believing that. Anton Ivanov, Sarah Boone is represent herself, fun time. Well, you guys can have fun with that one. Frankly, to me, I saw this coming with all the problem that she's been having with attorneys and basically running them off the case. It was a matter of time until she was found to have forfeited her right to counsel if she didn't just flat out make the decision to go pro se. You can forfeit the right to counsel through basically dilatory conduct. You're purposefully sabotaging their ability to work for you. And there seemed to be a pretty good record in this case of that type of thing going on. So that means it's going to be Darrell Brooks 2.0. I've seen that. I don't need to see that again. I'm probably not going to be following this, but maybe there will be some drama for everybody. I doubt there will be any difficult legal questions or anything like that, but not surprising an outcome to me at all. Melinderp, even if the issue is the plastic on scene, the Fed experts explained that with the thrown glass theory. Yeah, they did. I mean, that is a possibility. It is a possibility. Would have helped if that's the theory that they wanted to go with. Really would have helped if Karen had gotten on the stand and said that's what happened. You know, I think that's always the challenge when the jury is thinking about possibilities, what could have been. It can be very helpful in a case where the only question is, has the state met its burden of proof? Because if there are good alternative explanations, that should be reasonable doubt. It's just that the jury doesn't always buy that they are good, reasonable explanations if somebody isn't on the stand telling them. That is what in fact happened. And in this particular context, the only person who could do that would be Karen. It's the only person who could do that. So that would be a potential explanation, sure. But I could see a situation where a jury would not accept that without her saying that's what happened. Valhalla. What if they unanimously agree not guilty on charges 1 and 2, but hang on 3? Does double jeopardy apply to 1 and 2? Yes. So this is getting into the whole other complication in this particular case that I talked about before with that instruction on charge number 2, the one with all of the lesser includeds. Double jeopardy attaches to any charge that the jury acquits on. If they vote not guilty, you can't be retried on that. Only specifically charges that the jury hung on can they acquit on. Can they retry her on? So in your example, yes, double jeopardy would apply to 1 and 2. They could only retry her on 3. If that's all that they're going to get out of the prosecution, then that's going to weigh pretty heavily in favor of just walk away. You know, take what you got and call it good, because a motor vehicle homicide, you know, premised on negligence, I don't know. It's just maybe you'd still go forward with it. I don't know, but it's just not relative to where they started. You know, a very good end result. The concern I have is if they acquitted on 1, but they hung on 2. And the reason why goes back to that verdict form and how they wrote it out. Because they made not guilty all or nothing. The jury can only vote not guilty explicitly on the form without going in and like writing in things themselves, which you just can't count on the jury doing. The only option presented to them on the form is acquit her on everything or find her guilty of specific things. So the problem here is if the jury is following the instructions the way Judge Bev gave them the instructions, they're supposed to start with the highest degree, right? So start with the main charge, the voluntary manslaughter, and they're supposed to deliberate on that. If they find her not guilty, then they should proceed to the next one, the next lowest one, involuntary manslaughter, and consider that. If they find her not guilty, they should then proceed down to the motor vehicle homicide and consider that. So the problem becomes, what if they do just that? They work through it and they decide she's not guilty of motor vehicle, or she's not guilty of voluntary manslaughter, she's not guilty of involuntary manslaughter, but we can't decide on motor vehicle homicide. Well, then the all or nothing conditions don't fit for that form. They can't check that box. They have no way of indicating they've acquitted her on these 2 greater offenses. And that's very significant because double jeopardy would attach to those if she had been acquitted on them. And so under the terms of the jury's vote, if that's what were to happen, she should only be able to be retried on the motor vehicle homicide. But they don't have a way to indicate that. So that's the concern that I have with this verdict form and the potential problem. If they reach some verdicts, but they hang on count 2, what, if anything, are they able to retry her on? Because what, if any, indication is there about where they hung? I don't like it. I don't like it at all. That's why I really wanted the guilty, not guilty option for each specific charge, including the lessers. That's how we do it in my state. I think that's pretty typical. For whatever reason, they don't have that on their form in Massachusetts, and to me, it's just very blatantly problematic. My cat's name is Karen. I've been watching Bill Burr, a stand-up comedian from Canton, Massachusetts, who does stand-up about how corrupt it is. Wow, watching from Pensacola, Florida. I'll have to check that out. I've heard of Bill Burr, but I've never watched him. So I'll check that out. That could be eye-opening. That could be eye-opening. The best humor, of course, is that stuff that has the very deep grain of truth, even if you don't like to acknowledge that that's the truth. Yeah, I bet there's some good jokes there. The Chungi Show Live, poor Karen. Yeah, all of them. It's tough. It's tough to go through something like this and not be any closer to the end after all this than you were when you started. McRae, I'm behind, but what if the federal case results in charges before a retrial? Also, it's perfectly reasonable to think John threw the glass at the car. Yeah, it is perfectly reasonable to think that. It just didn't become part of the defense case. Maybe that's something they would reevaluate on a retrial. You know, if it gets to that point and they do have to, maybe they would look at potentially pushing that as a theory. It does give them the alternative to. The police planted the taillight at the scene because that is tough without being able to identify the mystery officers or really track Proctor and Buchanan's whereabouts that evening. It's a tight timeline getting back to the Canton Sally Port and then getting out to 34 Fairview when O'Hara's already on the scene. It's a tough sell. It's a tough sell. If the federal case results in charges before a retrial, there's nothing that precludes both of these things from going forward simultaneously. The main effect, I would think, would be that if any of the witnesses are charged, they would be well advised to invoke their Fifth Amendment right at this point in time. If they just stick to what they already said, are they really making it worse for themselves? Well, yes, if what they already said is perjury and can be proven to be perjury, you don't want to repeat it. It's another perjury charge. So that's really the main impact that I think it would have. It wouldn't preclude the Commonwealth from being able to go forward. It's not a situation where, because they're different prosecutors, different interests, different parties involved. So the feds prosecuting, hypothetically, Brian Albert, that wouldn't be binding on any related prosecution in which Brian Albert is a witness. I think it would just affect the likelihood that witnesses would be taking the Fifth. John Simons, if one juror holds out and refuses to deliberate, what can Bev do? So you can have, I'm losing my vocab today, guys. So much stress with the jury. The word starts with a D, and I can't quite find it. But yes, a jury who is basically refusing to engage in the deliberations in good faith. It came up in, I believe, didn't it come up in the Murdoch case? Wasn't that one of the situations where they came back and they said this juror is not intransigent? When the juror is intransigent, they would, that's funny. I gotta pull that up. There probably is a word for that, and if nothing else, I'm sure there's a good German word that explains exactly what that is. Juror intransigence can be grounds to remove a juror because it's misconduct. You're not engaging in the deliberative process. You're not following the instructions. If you're not willing to hear the other jurors out and fairly consider their ruling. So if you just put your foot down and I'm not budging and I don't care what else you have to say, that can potentially implicate that option. But again, it's tricky. That's a tricky one. Finding intransigence compared to just the juror, especially now that we've already had the specter of the hung jury out there, just that they've gone through everything, and it's not that they haven't considered it. It's not that they aren't willing to consider it. It's that they have considered it and it didn't change their mind. It can be a very, very fine line. But if they did find a juror to be intransigent, yeah, in theory, they can replace that juror and, bring in one of the alternates instead. But it's pretty rare that happens, because it's a little bit of a minefield to go down that road. Harley62 is a YouTube member. Welcome. And so is Sunflower709. Welcome, you guys. Thanks for being part of the crew. Entry required: Stoughton TH town hall meeting opposition against reformer lady police chief who ousted the police involved in non-suicide scandal. Hall full of Chris McAlberts. I believe Reed jury is polluted with McAlberts also. The town hall stuff, I haven't watched a lot of it. I know that there's different things going on in Canton and in Stoughton. The thing in Stoughton is that one's Rafferty. Am I right? Or is Rafferty the one in Canton? I can't remember who is who. But the one in Stoughton, it was something like she got a DUI, and I don't know, maybe potential liability implications against the town or something like that. I could be getting those things confused, but that's sort of what I remember. The Stoughton chief of police, just based on like the last statement that she put out about the Sandra Birchmore case, when the news came out about the family has a forensic pathologist who is saying that this is a homicide. It was pretty strong. I mean, it was pretty strong in favor of looking deeper, digging deeper, not engaging in cover up, not playing favorites just because police officers are implicated. Her statement, don't quote me, I'm not going to try to quote her exactly, but it was all along the lines of, I am an experienced investigator, and in spite of that, I was deeply troubled at the findings of this medical professional, and in my opinion, they warrant further investigation at the highest levels. That's a very strong statement, and it's not a thin blue line kind of statement to be making. So I don't know what else might be going on, in the ether that would be kind of mitigating against that and encouraging people to want her to be pushed out. But if it's the hall and the people who are part of the cover-up cabal, for lack of a better way to put it, that are leading that charge, then that definitely would make a lot more sense to me. This is somebody who has signaled she's not interested in helping out with the cover-up. Teresa K, hashtag free Zachariah Anderson. Can FBI get texts from rehomed phone companies? Phone companies don't always retain the text messages themselves. And I don't know how much this has changed over time, just given how kind of phone services have changed. And now there's all this cloud-based storage through Google, through Apple, iPhone and all that type of thing. It used to be that if you couldn't get it off the phone, very slim chance you would be able to get it from like the phone company records. Some phone companies, however you can, I have seen it. It's just not a regular thing. And I don't know to what extent they might have things that have been deleted, that they might have like the original record of that message being sent or anything like that. Generally, if you don't have the phone, you go server side. There's multiple computers involved in digital communications, and so if you lose one piece of the network, you try to find it in another piece of the network. But it can be a challenge. It can be a challenge finding things that have been deleted. Whack job. Could next defense be that John threw cup at taillight and Karen drove away in fear as Brian Higgins attacked John? Higgins put himself at the scene. I mean, the bottom line is they can put anything out there as theoretically possible if it's consistent with the laws of physics. The Commonwealth doesn't mind if it's consistent with the laws of physics or not. You know, they'll happily put put explanations out there that make no sense at all. But you know, for her to get a reasonable shot at selling the jury on something, yeah, she can pitch anything. The question is just going to be, is the jury going to be satisfied with the possibility, or are they going to be looking at this and saying, why didn't you get on the stand and tell us? Tell us that is what happened. That's the challenge. That's the challenge. They're not supposed to hold it against her for choosing not to testify. She has no burden of proof, but it's also not really unreasonable that if the defense attorney is going to tell you something did happen, they need to have some ability to prove that. And so if that did happen, you got somebody sitting right there who can establish that. So I think that's the real challenge that they have is frankly evaluating in the next case. Do we need to hear from Karen what she remembers about what actually happened? I see from the chat that it's Rafferty is in the Canton Police, and I kind of figured I had those names. I can't remember the name of the one in Stoughton. I kind of knew as soon as I said that. I think I've got those names mixed up. Rafferty is the new one in Canton, who is, you know, she would have been the chief of police when that Sallyport video, the mirrored Sallyport video, was extracted and handed over. So, Lily Smith, I still think the McAlberts have someone on the jury. Why else would they show up on the last day? They're all crooked. Hard when cops are crooks. The issue I have with it is just, you can't say it never happened. You know, you definitely can't say it didn't happen. I have no proof that it didn't happen. It's just, it is tough. It is tough to pull something like that off. And it largely, to pull it off without any kind of sense from the defense that it's going on is hard. The defense picked this jury too. You know, that's the thing that you have to bear in mind. The defense had the opportunity to talk to every one of these people and to feel them out and to exercise their challenges on, you know, people that they thought were going to be worse than these people that landed up on the jury. It doesn't mean that they love everybody on the jury. It doesn't mean that they haven't had to accept people that they might not otherwise have preferred. But I just have to think if they had any whiff of at all that somebody would be inclined to something like this, that's just it's a no-go. It would have to be they would strike that person. Doesn't rule out they can't be got to after the fact, and like I said earlier, it really doesn't rule out that these things aren't being done deliberately or intentionally. That it can literally be a person sitting there on the jury with no prior connection with any of these people, but they can see the writing on the wall and they can understand crystal clear, you guys have power, and if I vote this way, you're my friend. I'm going to make sure you know that I voted this way. And if I vote this other way, you're my enemy and you're going to know. You know, it's going to come out. So that can happen without any effort of persuasion of the McAlberts at all. You know, whether they show up or not, just understanding the dynamics that are at play in the case could be all that it takes. W.M. Penguin, why are judges so averse to recusing themselves? Surely it should be a good and beneficial thing to recuse to show the absolute minimum bias. There's a couple reasons why. I mean, judges, number one, don't want to give the impression that they aren't fair. That's their basic qualification as a judge, is to be fair to everybody in front of you. And so they don't want to admit that they're not. I think there might be some fear that they're opening the door to people saying, well, if you admit you can't be fair, then you know you can't be fair lots of times, and maybe invite disqualifications or something like that. The counterpoint, obviously, it's more It's just more believable for somebody to acknowledge when they do have pretty clear bias, than to just stay in denial. Like somebody who admits that they're biased, I would probably tend to trust their judgment a lot more about whether they are biased or not, just because they have a record of recognizing that in themselves. And we are all human. We all have biases. We all have them. Nobody is exempt from that. I think the other piece of it too is just it's a little bit institutional, because you are burdening the other judges. If you say, oh, no, I can't be fair in this one, sorry, then you back out, and it becomes somebody else's problem. They have to pick up that part of the workload. So if you're in a court where you have, good relationships with your fellow judges and stuff like that, you may not want to do that. It may just be considered the collegial kind of thing to do if it's not a literal disqualifiable conflict, it's best to just suck it up and do the best you can and not make it somebody else's problem. So I think it could be a combination of those things. But I think personally that acknowledging bias should not be something to be ashamed of. I think it's something that, yes, we should respect that, and we should appreciate and applaud and honor that, because we all know that we have them. And so pretending that you're completely and totally unbiased in all ways in every circumstance is just not realistic. James Casatelli, if I ever get murdered, I hope you cover my case. Why? You want your murderer to go free? No, I'm kidding. Let's not test that theory. How about that? Millie Martinez, if it's a hung jury, how long will Karen have to wait before she knows if she will be retried or not? So typically they will have to retry her within whatever the speedy trial, time limit is. So it's not uncommon. You just go forward as if you're going to retry her, get the trial date and stuff like that. You just get the ball rolling before you make a final decision. And, you can make it along the way. You can decide, okay, well, never mind. I'm just going to go ahead and dismiss. I'm going to back away. But they keep the option open to be able to do that. Sometimes the court will ask them specifically, electing to retry or not. Typically, if they are sure that they're not going to retry her, well, then you're going to find that out, sooner rather than later, because they don't want to continue dumping resources in the case and spending time on it and stuff like that. They want everybody to be on notice that, you can go back about your lives. You're not going to be called as a witness again and stuff like that. But if they aren't sure, or if they want to hold the option open and think about it, then as long as they plan to bring her to trial within the speedy trial period, they can do that. Z, please, NBC Boston, day 9, 59, 529.50 is jury tampered. I don't know what this is, and I just don't know if I can hunt this down in the time frame that we have. Let me see. Let me see. Find their YouTube. NBC 10 Boston. If they have a playlist, that would make it easy, but they don't really. I'm not going to be able to hunt this down, but I will see if I can take a look at it. Let me see. Day 9. Okay, here we are. Day 9, 529.50. Okay, I found it. I'm going to pull it up. We'll watch it together and we'll see. So I'm starting a little bit early here.
No further questions.
Okay, thank you very much. All right, Ms. Albert, you are all set.
Thank you.
Okay, that was Nicole Albert coming off the stand. I don't know, because she
Your
looked at
next
the
witness,
jury.
Mr. Lally?
Yes, Your Honor.
That's all I really saw. Her looking at the jury is not grounds to think that the jury is tampered with. It's not against the rules to look at the jury. Ms. Holmes, 66. Andrea, you are being terribly nice about Bev trying a possible new trial. Bev should be in prison. She's a tyrant and controlled this trial start to stop. I don't particularly like her as a judge, and I don't think I would enjoy practicing in front of her. I suspect we would probably butt heads about things because she has very strong opinions, as do I. Yeah, I can see certain situations where I might have maybe had a shorter fuse than Mr. Jackson has had. It kind of took him a while to boil over. But I haven't seen anything explicit that I can point to on this record and say, this is disqualifying as a judge. I just can't. I can look at things that I don't like. I can look at things that raise my eyebrows. I don't like the whole politicization of the bench anyway. It doesn't frankly even matter if judges are elected or if judges are appointed by some political figure as they are in Massachusetts. That means you need to be a political animal to be a judge. And to me, that's like the antithesis of the skill set that you should be looking for in a judge. A judge should be like the furthest removed from the influence of public opinion and popularity and all those types of considerations. Like preferably your judges should be hermits. They should be big old law nerds who just want to, get the decision right and don't have a whole lot of concern about whether the community likes it or not. That's my perception of the judicial role. But that's, not reality. That's just, if I were the ruler of the world and I were setting it up, I'd try to get that, I'd try to get that kind of qualification in place. But I haven't seen anything that isn't within the discretion of what judges are allowed to do, even though I don't like them and I don't agree with them. They're rulings that I don't necessarily think are fair, but most of them are within our discretion. So just because I would make them differently doesn't mean there's grounds to boot her off the bench. M4A now, do you think the FBI will use the witness testimony in this trial in a case against someone like Proctor? Could they be waiting until this is over? Well, definitely one of my theories about if the feds are investigating the investigators, if that's what this is all about, then yes, it's very possible they would be using this trial as a perjury trap. I mean, it's almost inconceivable that they wouldn't. They know that it's happening. They've chosen what information they wanted to provide to the defense, and a conceivable reason for that is because it is helpful to them. This is the whole, trying to sort out what is going on with this TUI process, because it is, to my perspective, it's really unprecedented that they would hand over so much as part of an ongoing investigation, because they have that easy out that no, if I show my hand, it's going to impair my ability to move my own case forward. Well, what if it doesn't impair their ability to move their case forward because they get to have a free confronting these people under oath? I mean, Proctor could have pleaded the fifth. He could have, but it sure would have been bad. Sure would have been bad. If the FBI goes, though, and knocks on his door and wants to talk to him about this same stuff that they've handed over to the defense, he's probably invoking the fifth, because there's no real downside to that, to doing it in private. Doing it on a public stage or in a situation just where everyone's going to know that's what happened. Yeah, a little bit more of a problem. So from a strategic standpoint, I could see that making a lot of sense as a play by the prosecutors. Give the defense just enough to be able to confront these people, get them on record under oath with their story, and then they tell the truth or they don't. And then you've got potentially a free perjury charge. It's just one more bit of leverage you can put on them to get a resolution to something. Fletcher Boy, big news on Sarah Boone. Yeah, we just heard. I didn't hear if she waived or if she was found to have forfeited her right to counsel, but either way, she is going forward pro se. We are getting Daryl Brooks 2.0 in a female body. So we'll see how that goes. I'm sure it will be very dramatic and exciting. Rebecca Lilienfeld. How does DA Morrissey get away with his pretrial lie that the Commonwealth had ring video of Karen running John over? I don't remember. Did he explicitly say that? I remember that news channels had reported that there was ring camera video, but I remember that it was reported in some of the early news reports, but they had done it in this very ambiguous language, right? Just that there's ring camera video, like there's deniability based into the statement because it's not crystal clear that they're saying there's ring camera video of Karen hitting John, or just there's ring camera video, which there is. It's just at John's house and has nothing to do with the accident, and is actually, in some ways kind of exonerating towards Karen. And so it's just presented in a misleading way, but they have that deniability to say, well, that's, we just said there was ring camera video. We didn't say it was ring camera video of the accident. So I think that's how they get around it, honestly. I don't remember him saying that explicitly. That the press conference was problematic for all kinds of reasons, and Bev even acknowledged, this is very problematic. This goes against the basic ethical limitations that apply to a prosecutor. The types of things that they can say pre-trial to a potential jury pool. You're not allowed to do that. So even Bev recognized that he crossed the line in that particular statement. But this precise one, I don't think we can attribute to him. And to the extent this is already out there, that's my answer to you. That's why nobody's getting in trouble about it. It was plausibly deniable. Well, we didn't mean it was ring camera of John, just that there was ring camera video. And then the way it gets presented creates the false impression, but that's not on them. The reporters just misunderstood. Wink, wink. Theory Neutral, taking this opportunity to share while sending Andrea money. Thank you so much. That Court TV is the CNN of true crime. Interpret that as you wish. Frankly, I thought CNN did a pretty decent job last night. Definitely don't always say that, but yeah. Court TV's got a perspective, don't they? They've got a view. They've got guests that support certain viewpoints. Don't know that they are the C-SPAN of true crime that they maybe used to be. Charlie Lynn, if the judge applied the same restrictions on experts of Commonwealth as defense, she would need to eliminate most of the Commonwealth experts and limit a lot of testimony. So this is definitely something that could come up in retrial, because now they've seen what the people say, and the defense can be on notice. Hey, judge, if Trooper Paul is going to repeat all that bullshit that he said in that first trial, we need to have a Daubert hearing. Okay, we need to establish his methodology, that it's valid, that it's scientific. We need to establish his foundation to be able to make these types of claims. We're going to move to exclude his reconstruction on the grounds that he's not qualified, and it doesn't meet the elements to be helpful scientific evidence for the jury. That's the upside of the dress rehearsal. It does go both ways. And so those instances where the Commonwealth crossed the line, yeah, now the defense is on notice that happened, and they can move to prevent that from happening again the second time around. So to the extent there is a silver lining, if we get a retrial, that could be one of them. Damaris San Giuliano, sorry if been asked already. Can Bev poll jury how many are not guilty, guilty? If no verdict by Monday PM, see if 11-1, 5-5, etc. as surely would be useful. No. I understand the perspective that it would be useful, but it is categorically prohibited for them to do that. The reason why is because it is perceived as coercive to the minority jurors. You are putting the spotlight on them. You are making it seem like they are the problem. And they may not be the problem. The minority jurors could be the ones that are taking the most reasonable view of the evidence. They've taken the most notes. They're most familiar with what's happened. They're just dealing with a bunch of numpties who slept through most of the trial. You know, that can happen. So no, that is one of the areas in the law that is very crystal clear. Per se, cannot ask the jury about what the numbers are. The jury has been known to volunteer them. If they write it in their note, you're not obligated to blind yourself. You know, if they say, look, we're split 10-2 and we're not making any progress, nobody's going to be able to budge any further. Okay, I mean, they've told you, but you cannot ask about it. Very clear. Damaris San Giuliano, duh, not 5-5, but you get the point. Yeah, I got the point. WM Penguin. The problem with the FBI perjury charge thing, what if they provided the evidence, they get what they want, but for some reason, Karen is found guilty? A couple of ways to look at this. Number one, it's not their problem. Their responsibility is not to Karen Reed, and that's not their primary consideration. They, I mean, we would like it to be, we would like to think, my gosh, if they know that there is a miscarriage of justice happening here, that they would do something about it. But they don't necessarily have the power to, you know, they don't have the power to come in and just shut down a state prosecution because they don't think it should be happening. If it's a question of they have additional evidence that they didn't provide, well, if it comes out during their own charge, their own case, their own prosecution, then Karen can potentially rely on that in post-conviction proceedings because that is new evidence that was not available to her at the time. And that's one of the classic grounds to be able to go back into court and ask for a new trial. So it's not ideal, definitely not ideal. But it's not a situation where, like, if she doesn't have it by trial, she's completely foreclosed from ever being able to rely on it. But I think the bottom line here is that hate to say it, but that's not their concern. That's not their focus. Their focus is on their own investigation and getting their targets. And if she's an omelet, an egg that gets broken to make the omelet of that case, then they may very well be willing to do that. Minnesota knows. There is no way Lally lets this go if there is hung jury. He has a Trump-level ego with a Biden personality. We should demand better from our justice system, from police to judges. Lally is unaccountable to us because he is just a staff person at the DA's office. I mentioned before, I don't know if Massachusetts has civil service protections for people like local prosecutors. Some places do, some places don't. But that makes them the same, you know, deep statey kinds of people as the people who populate the administrative state in our government, who do most of the day-to-day work of deciding how the laws apply to you and making up new laws to apply to you and deciding if you should be penalized and all of those types of things. Those decisions are all made by people who aren't accountable to us. It's very alarming to me, very disturbing, this growth in government. I think it's possible he would let it go if there is an acquittal, like if there's an explicit acquittal on the higher charges, you know, then maybe he would, because it's just hard to justify going through all this again if all they have on the table is, you know, leaving the scene. If that's all they had, you know, no. Even motor vehicle homicide, it's marginal. But you know, they've already bought in that the prosecutors can be some of the worst people when it comes to wearing the skin suit, because they love to wear the skin suit of the victims. They represent the victims. They may have never talked to the victim the entire time. The victim may be nothing more than an idea in their mind, a little fantasy that they've spun up about who this person is and how the crime happened and everything. But they will wear that skin suit because that justifies them feeling like they are righteous and proper, and they're fighting the good fight, that kind of thing. So he could very well, you know, be that type of prosecutor who's like, well, no matter what, we've got to do this for the O'Keefes. Mabulus, why wasn't Chief Berkowitz called? You know, the defense didn't call a large number of their witnesses, and option number one is because they didn't know what he was going to say. Very high risk to put somebody on the stand if you don't know what they're going to say. If you haven't already deposed Chief Berkowitz, which, you know, I'm not aware that they have. If you haven't already done that, then you're just fishing on the stand, and that can really, really come back and bite you. They decided it wasn't going to be helpful. Anything that they did have wasn't going to materially advance the case. I mean, the best evidence we had about Berkowitz's involvement was what? There was the apparating out of the Sally Port with Proctor when they were walking out, or maybe he apparated in. I forgot. Was that the weather? You know, the localized fog that Sergeant Buchanan described to us. There was that. There was just his general presence that day, and his friendship with Higgins. It's just, if they don't have anything to really nail him down on, if they don't know something that they can prove and substantiate, then they have suspicious circumstances, but all they'd be doing is just inviting him to give a shameless explanation for why it's all totally okay. And if they don't have a way to prove that what he's saying isn't true, then it's just not ultimately that helpful to the case. So I think he was really on the table as just, they had him on the witness list as really a just in case. If something came up where maybe it would be good to call him, okay, but I have my doubts that he was ever, you know, anticipated to be a significant part of the defense case. Michelle C., can you explain the Chevron decision in 2 sentences? I'm clueless on this one. This is a challenge. 2 sentences. The administrative state no longer has the authority to decide for themselves what their authority is. That's sentence number 1. Sentence number 2 is, if Congress wants an agency to do something, Congress is now required to explicitly tell the agency what it wants it to do. That's my best explanation. Chevron is about ambiguous congressional enactments. When Congress adopts a statute and says, I'm going to create an executive agency to administer this and carry out the requirements of the statute, there's all kinds of examples of this, right? The Environmental Protection Agency, the Department of Energy, the Department of Labor. I mean, you name it. Every executive department that exists out there, there is some piece of legislation that Congress adopted that created that agency and gave it a purpose. And the Chevron doctrine had basically said, well, anything that Congress is silent about, or is ambiguous, if the statute is ambiguous about the agency's role on a certain issue, or the rule, the standard that applies, or even their authority to act, their interpretation of that statute and whether it applies to them or not is what controls. The judges, the courts don't get to come in and interpret the statute themselves. They just look at, has the agency come up with an explanation that fits these words in the statute? And if it's permissible, even if the court thinks it's wrong, they don't get to substitute their judgment. That was the previous rule, and so that is now gone. And that means courts are going to have a much, much, much bigger role to play in interpreting whether agency actions are appropriate and are authorized by the statute that applies to them. So it's a very, very big deal. Bassam Ramadan, do we know how Karen Reed can afford these high-powered attorneys? Is she rich? What's her work family background? Because not many can put such a defense. Thanks. My understanding is she has some family money. Her father is wealthy and I think may have contributed some to her defense. She herself is a finance professional. She's been an adjunct professor and stuff like that. So she has her independent money as well. She has done very well for herself. That said, don't think it's an unlimited war chest. So don't know how many times she's going to be able to afford to do it. Chelsea D, how will the testimony of the crash daddies affect whether the Commonwealth retries the defense case? They had only reports, but now know exactly what they found. Why? Can see both ways on this one. Now the Commonwealth knows what they're going to say. So the Commonwealth is prepared to try to explain it away, to try to poke holes in it, to try to find problems with it, to submit it to a different expert and say, you know, what did they do wrong here? Anything like that is potentially going to be on the table. You'd like to think they'd be like, oh, if it couldn't have happened, then we should just defer to that. But no, because they already knew. They already knew the gist of what the crash daddies found, right? And decided to go forward anyway. So I don't know that it's not necessarily going to make a material difference on their decision. Law Kong Express, Andrea, your coverage has been outstanding. Second the motion, free Zachariah Anderson, mailboxes. Thank you so much. I gotta confess, the Zachariah Anderson case is one I am not nearly as familiar with as I would like to be. It has been on my radar for some time. I remember when it was happening. I watched people watching it. I just didn't have the time to sit and watch it myself. It's one where I would like to, because I'm sure it's on appeal, and it's kind of in the back of my mind that like, oh, I need to check in on that, because that, if anything else, you know, is my wheelhouse. The appeals are my wheelhouse. I'd love to be able to take a look at that and see what he's working with, and you know, if there's a good chance that there could be a retrial, could be a reversal, anything like that. I know a lot of people whose opinions I respect very highly were quite dismayed by the verdict. And that is, yeah, one of the very big difficulties of being a criminal defense attorney. Sometimes you get jury decisions that infuriate you. It's just so unjust. And it's very limited what you can do about it. Kirnoth, does Chevron deference repeal finally destroy ATF? It does not destroy the ATF. What it destroys is ATF's ability to go in and expand what firearms, what munitions, what add-ons, you know, things like that the statute doesn't specifically say it can regulate. It limits its ability to go in and fill in the gaps where Congress didn't speak. It limits their ability to, you know, expand the scope of who their regulations apply to, all of that kind of thing. So none of these are doing away with the administrative state. The administrative state, the ATF, all of these agencies, the fundamental problem there is, I don't remember the source of the decision, but it's just the idea that Congress can delegate its lawmaking power at all. This to me is a real problem, because lawmaking, that's the basic function of the legislative branch of the government. So you have a separation of powers problem with the legislature basically just handing off its role to an executive branch department, but also the problem that Congress is accountable to us and agencies are not. So agencies deciding the rules that we're all going to live under and who these rules apply to, they have no political accountability to that. That's a big problem to me. I'm in the minority on that, you know. My view is that if there's going to be legislation, Congress needs to say what it is. And so at least Chevron has kind of put us back there. It has put more of the onus of making it clear about what the law is, who it applies to, and what the responsibility of this agency is. Congress has to spell it out. They got to do their job. They got to reach consensus, whatever they need to do to be able to get a bill through. And then that's going to be what controls. It isn't going to be a situation where whoever wins the presidential election then gets to capture the administrative state and take over a massive part of the rulemaking process by appointing their agency heads and so forth, resetting policy in the executive branch. So no, it's not going to destroy ATF, but in general, the administrative state as a structure took a very, very big hit today. You guys have been very patient. I appreciate you waiting for me to come on today. As soon as I saw the jury was coming in with a question, of course, right as I'm ready to get live with Eric, with Eric Hunley, I told him I would go on, and I like to keep my commitments. So I didn't want to pull away, but I just knew instantly, oh, it's gonna be a mess today. People are going to be very alarmed. So I do appreciate you being patient and waiting for me to be able to make it over here, to be able to get some of those basic questions answered about what exactly is the structure of all of this in Massachusetts anyway, what's going on here, what's going to happen next. So hopefully you guys have found that a little bit helpful in terms of sorting out where we're at and where we go from here. I think the bottom line is we come back Monday and we see if the jury is still able to make progress. And if they are, then fingers crossed that progress is moving in the right direction. If they're not, then we start getting into that circumstance where we get that dynamite charge that this is your last chance to try to sort things out. And we'd really, really like it if you did, but you can't sacrifice your conscience, your conviction. You just have to keep an open mind as much as you can to the perspectives of others. But if you have done that and there is no more swaying you, then it is what it is. And as much as everybody would like a verdict, you just can't always get one in every single case. So for now, let's be like the jury. Let's take the opportunity to enjoy the weekend, clear our minds, and we'll plan on being back on Monday. At some point, I'm not going to promise that I'll come on at 6 a.m. when the jury comes into to Bev's courtroom to continue, but I will certainly be monitoring throughout the day. And, hopefully this time, if there is another question or a note or something like that, we'll be in a position to go ahead and come live and plan to address that. So not going to leave you guys hanging. Not at this point. I will be here when there are things to talk about. So with that, guys, please do enjoy your weekend. Thank you so much for joining me. Thank you for your support. Thank you for your great super chats. Thank you for the memberships. Thank you for all of your contributions to the chat and making it the awesome place that it is. You guys are awesome. Please go enjoy your weekends. Let's close with another one of those nice, calming, collective breaths. Deep breath in, let it all go. Yes, it'll all be okay. It'll all be okay. All right, guys. Enjoy your weekend. Take care, and I will see you next week.